Welcome to the Employment Law Channel here on the Legal Broadcast Network. I'm Scott Drake. In this discussion, we're going to be talking about offer letters to potential employees in the financial services industry. My guest is Katherine Blostein. She's an associate with Outten Golden's Executives and Professional Practice Group. They are an employment law firm in Manhattan. Katherine, it's a pleasure. Thanks for joining us today.
Thanks so much for having me.
So, Katherine, here's the scenario. So you are changing jobs on Wall Street. You're pretty excited about it, I'm sure. The employer sends you an offer letter that includes what you believe to be a guaranteed bonus. But before you sign it and resign from your current job, what are some things that people need to know about guaranteed bonuses in these types of offer letters? What should someone be aware of about the terms of the bonus?
Well, Scott, first, we always prefer to see a few terms that actually state that this is a guaranteed bonus. So the amount should be qualified by words such as a minimum guarantee or an amount equal to at least a certain amount of dollars. If you are employed in the U.S., it should be dollars. And the offer letter should also describe what portion of the bonus will be paid in cash and what will be allocated to deferred compensation, such as grant of restricted stock, stock option, or any other form of deferred compensation. If the company is not willing to commit to a percentage or a specific number, there should at least be a representation that the employee will be treated the same way as other similarly situated employees in her level.
And so talk about the timetable here. When should this bonus be paid? Is that something that's also stipulated in the offer letter?
It should definitely be specified in the offer letter itself. Sometimes it appears in the plan, but the employee or her attorney should be checking when the bonus will be received. And the reason for that is any annual bonus, whether it's guaranteed or not, should be paid to the employee within 2.5 months of the end of the company's fiscal year. If it is not, then it might subject the employee to possible deferred tax issues and thus subject the employee to possible tax fines.
So, Katherine, what if someone is terminated before they receive the bonus? What happens then?
Scott, all of my clients think they're entitled to it, and it doesn't matter what the contract says. Unfortunately, unless the contract specifically states that the only reason why the employee wouldn't get the bonus is if she's terminated without cause or resigns, voluntarily. And the company could make an argument that if such language is not in the offer letter, then the employee is not entitled to the guarantee. So really, it is very important to get the correct language in the offer letter that protects the bonus, and that the only reason the employee wouldn't get it is if she's terminated for cause or if she resigns voluntarily.
So would it hold true also if something unfortunate happens to the employee? For example, they pass away, or something happens outside the workplace or in the workplace and they're on disability? What happens to the bonus then?
Typically, an employee should get the entire guarantee, or at least a pro rata portion of it, calculated through the date of the termination due to death and disability, if, God forbid, something unfortunate happens. Again, if this is not explicitly spelled out in the bonus plan that governs the bonuses of the company, or the offer letter itself that governs the guarantee, then again the company can make an argument and should be successfully able to make an argument that the person wouldn't be entitled to it.
Katherine, in closing, to those who are fortunate enough these days to receive an offer letter, is there anything else about them that we should know about?
Well, I think that all terms of an offer letter, any kind of offer letter or contract governing your employment that you get, are very important and should be carefully reviewed by the employee and her attorney, and possibly an employee should be retaining an attorney to negotiate the terms of the offer letter, especially if it has a guarantee, because you want that protected, as we discussed. But I think in regards to I think as it relates to a guarantee, the one term that is very important is the choice of law and the forum selection clause, which basically states where the employee would be able to bring a dispute over the offer letter or the contract, and what state law would govern that dispute. And the reason why that's important is because an employee has to know where they would be filing a lawsuit or a proceeding if they want to enforce the terms of the contract. And for financial services employees, it is important to note that most of the time their offer letters or the company policy that they will be asked to sign on to will require mandatory arbitration. For financial services employees, for many firms, they will be subject to FINRA arbitration or a different arbitration organization such as AAA.
Well, we appreciate you sharing your time with us and your expertise. Katherine Blostein is my guest. She's an associate in Outten Golden's Executives and Professional Practice Group. Katherine, thank you.
Thank you so much.
You're watching the Employment Law Channel, an affiliate of the Legal Broadcast Network.